Have you just gotten an environmental letter or notice that feels way more serious than anything you've dealt with before? And are you trying to figure out if this is something you can fix or the beginning of a legal nightmare? In this video, we're going to walk you through how to tell how serious your situation really is, who you need on your side, and what you should be doing right now to avoid making things worse. And by the end, you'll have a much clearer picture of where you stand and what the smartest next steps actually might look like. Hey there, I'm Doug Ruhlin from RMA, your environmental experts. We work with businesses when regulators show up, when attorneys get involved, and when things suddenly go from, this might be an issue, to, oh wow, this is real. Hey, one quick thing right up front just to set expectations. Here at RMA, we're environmental consultants, and we're part of this puzzle all the time. But to be clear, here at RMA, we're not lawyers and we're not a law firm. So this is not legal advice and not meant to be construed as legal advice. And just because we're consultants, we're not your consultant yet. Think of this as general guidance meant for a broad audience, not a precise roadmap for every specific situation. If you want advice tailored to your specific situation, reach out to us and we'll talk you through it. All right, with that out of the way, let's jump in. Now, if you're dealing with some sort of environmental issue, the very first thing you need to figure out is whether you're actually being sued or whether you're just in trouble. That distinction matters more than most people realize. A lot of businesses panic the moment they hear words like violation or enforcement. In reality, many situations start and might even fizzle out well before anything ever reaches the possibility of a courtroom. The most common starting point is a notice of violation, a warning letter, an inspection report, or an administrative order. These are tools regulators use to get you back into compliance, not to immediately drag you into court. Usually that means something basic but important is missing or being done wrong. A required plan doesn't exist. A permit has expired or was never obtained in the first place. Operations don't match what the permit allows. Records, inspections, or trainings haven't been completed. These situations are serious, but they're often fixable if handled correctly and quickly. In many cases, an environmental consultant alone can help resolve the issue by identifying the problem, fixing it at the source, documenting compliance, and showing the regulator it's been addressed. If this is you, congratulations. You are probably not going to get sued. Reach out to us and we should be able to help you clear it up pretty quickly. Now, things change when you see language about litigation, penalties, citizen suits, or formal complaints filed in court. If you've received a demand letter from an attorney, a citizen suit notice, or anything talking about a true lawsuit, you're dealing with a much different level of exposure. If you're not sure which bucket you're in, that's completely normal. A lot of enforcement documents are vague and confusing. Reach out to us if you need help figuring out how serious your situation is. Now, once you've determined that this is a legal issue that could potentially go to court, the next thing is getting clear on what actually happened, how it happened, and who's coming after you. Many environmental cases start when something left your property that wasn't supposed to. Polluted runoff, wastewater, sediment, fuel, chemicals, dust. Once something migrates off-site, especially into a storm drain, creek, wetland, groundwater, or neighboring community, scrutiny ramps up fast. Public resources and spaces bring more urgency and far less tolerance for delay. Other cases focus on land disturbance, wetland impacts, erosion leaving a site, or grading that affects downstream properties escalate quickly because they're visible and easy for someone to point to. Then there are cases involving alleged harm or exposure. Claims that someone was exposed, got sick, or was even physically hurt immediately raise the stakes, even if the facts are disputed. How the issue happened matters just as much as what happened. Regulators and attorneys will want to know whether this was a one-time incident or something that went on for months or years, whether anyone knew about it, whether it was addressed or ignored. A true environmental accident is treated very differently than a known condition that went on for a long time and was tolerated. Prior violations, warnings, or repeat issues change how the current situation is viewed. And finally, who's accusing you matters a lot. A single disgruntled neighbor with a brother-in-law lawyer is very different from a well-funded third-party group with experience, deep pockets, manpower, and a willingness to make things public. That affects how aggressive the case becomes and how long it might drag on. Okay, on to the next step. At this point, here's the uncomfortable truth. If you're truly facing environmental litigation, you're almost certainly going to need outside help. Environmental lawsuits are made up of two separate but connected problems: a legal problem and a real-world problem. Both are complicated and usually can't be handled by a business internally alone. On the legal side, this is where an experienced environmental attorney comes in. And that word environmental really matters. Environmental regulations live in thousands of pages of federal and state law. They're technical, highly specific, and totally unique. How enforcement works, how penalties are assessed, and how cases move forward is very different than a typical business dispute. A general business attorney or corporate lawyer may not know how to navigate things like improper discharges, permit conditions, environmental justice zones, or how these lawsuits typically play out in real courtrooms. That lack of familiarity can slow things down, lead to missteps, or unintentionally escalate a situation. A good environmental attorney, on the other hand, works in this space every day. Their role is to manage this legal strategy and communication, including responding to regulators or opposing counsel, handling deadlines and filings, translating technical facts into legal arguments, negotiating settlements or consent orders, and representing you if things ultimately wind up in court. What they are probably not going to do is lace up the boots, walk your site, and start fixing problems at their source. It's not a knock on attorneys, it's simply not their role. But that's where environmental consultants like us come in. Consultants deal with issues in the real physical world. We go on site, see what's actually happening, identify the root cause, explain the regulations in plain English, and help stop ongoing problems. We update plans and permits, implement corrective actions, and document everything so there's a clear record showing the issue has been addressed. When these two work together, an environmental attorney handling the legal side and an environmental consultant fixing the technical problem, outcomes are almost always better. Think about it this way. What would you rather have your attorney say? The facility is still working on understanding the problem and trying to fix it as best they can, or the facility has retained a qualified environmental consulting firm that has evaluated the issue, corrected it, and put controls in place to prevent it from ever happening again. Working with a strong environmental team tells regulators and courts that the problem isn't being argued away, it's being taken seriously and fixed. So here's what you can do right now. Early on, the goal isn't to fix everything overnight. It's damage control. That starts with preserving what you already have. Don't delete emails, reports, photos, logs, or records. Don't clean things up on paper or try to rewrite history. Just gather and organize what exists, permits, approvals, past violations, all of it, and leave it intact. If something is actively happening, a discharge, a release, a piece of equipment causing the issue, stopping it safely and reasonably is a smart move if you can. A problem that clearly stops once it's identified is viewed very differently than one that keeps going until someone forces you to stop. At the same time, be thoughtful about what you document and how you explain things. Well-intentioned notes, emails, internal messages, or photos taken before the full picture is really understood can sometimes create more problems than answers. And this is the point where experience really matters. Reach out to us or another environmental consultant and talk through what's happening. That early conversation often determines whether this stays a technical compliance issue or becomes something that needs an environmental attorney involved. And getting that call right early on can save you a lot of time, stress, and money later. Okay, speaking of money, let's talk about cost, because I know you're wondering what to expect. Frankly, this kind of situation is rarely cheap. Lower-end cases might cost a few $1,000s if they're caught early and mostly involve paperwork. Mid-range cases often land in the tens of thousands once investigations, oversight, and legal coordination are involved. More serious cases can easily push into the six-figure realm when there's environmental impacts, cleanups, attorney's fees, or court involvement. But trying to save money by waiting or guessing your way through this almost always backfires. Once enforcement starts, delays and half fixes usually make things worse, not better. So how does all this end? As for outcomes, there isn't a single path these situations follow. Some cases are dropped entirely when allegations don't hold up, impacts are overstated, or issues are corrected quickly and documented properly. That does happen, especially when professional help is brought in early. More commonly, cases resolve with corrective actions and reasonable penalties. The problem gets fixed, controls are put in place, and the business moves forward, sometimes with manageable fines or settlements, follow-up reporting, or oversight for a period of time. Others fall into a more demanding middle ground, where larger payouts, long-term oversight, operational restrictions, or required changes to how a facility operates become part of the outcome. These cases are manageable, but they might change how a business runs day to day. And in the most serious situations, usually when impacts were significant, ongoing, intentional, or ignored, the conversation can expand beyond the business itself. That's when personal responsibility for owners, officers, or managers can come into play. Where a case lands on the spectrum depends heavily on what happened, how long it went on, and how the situation is handled once it's identified. Early, thoughtful action almost always leaves you with more good options than waiting and hoping the situation resolves itself. So here's the bottom line. If you're dealing with some type of environmental violation or lawsuit, the goal isn't to necessarily win the argument. It's to protect your business and get you through this without turning a bad situation into a worse one. If you want help understanding where you stand and what to do next, reach out to us here at RMA or consult qualified environmental legal counsel. Here at RMA, we've been through this with a lot of businesses, and we'll help you move forward with a plan instead of crossing your fingers and hoping for the best.